All right, welcome back to the Prima.Law Podcast. I'm your host, Attorney James Betzold. As always, this show is brought to you by Prima.Law, and we'll tell you a little bit more about that later in the show. First, I want to dive right into it. No secret police. No vigilantes. Sounds like a pretty good idea, right? Well, those are the names of a couple of statutes recently passed by California and signed into law by Governor Gavin Newsom. The No Secret Police Act, which is SB 627, and the No Vigilantes Act, SB 805, target federal immigration enforcement tactics that the Trump administration has been using in places like Chicago, Portland, and many other places in the United States. For example, walking around in masks, snatching people off the street without any badge numbers, identification, a terrible and dangerous situation that we've talked about repeatedly in this podcast, right? These are dangerous things because you never know who's going to get confused and start shooting back. Okay, it sounds awful, but it is literally the practical consequence of doing these sorts of things. If you know it's the police, yeah, normal people are not going to take extreme measures. But if you don't know it's police and you see someone getting kidnapped or abused or something like that, we have protective instincts as humans. So we're going to talk about the No Secret Police Act, the No Vigilantes Act, and as you can imagine, there is now a federal lawsuit against the state of California and Governor Newsom and their Attorney General, challenging the constitutionality of those as applied to federal officers. Of course, that was filed by the Trump administration just days ago. The name of that case is U.S. v. California. All right, we have the statutory citation for that as well. So United States versus California in the Central District of California, federal court, case number 2:25-CV10999. Okay, so for all the complaining we do sometimes about news or media sources not giving us those details if we want to go look and see for ourselves, there it is. But let's review some of the basics of the No Secret Police Act and the No Vigilantes Act. So these laws actually prohibit federal law enforcement, including ICE, Border Patrol, and Homeland Security agents, from wearing masks or face coverings during enforcement operations in California. Now, this also includes to state police and state actors, except in cases where protective equipment is required for health or safety reasons. Agents that are operating in California, they have to clearly identify themselves. And we've talked about this. If you're not clearly identified as law enforcement, people may get the wrong idea and people may act rashly and in manners that put officers in danger, which we do not want. Don't do it. Be careful. Stand back. Now, the part of the problem is, again, they're wearing masks. Part of the other problem is a lot of these ICE or Border Patrol agents are not wearing a name tag or a badge number. And this is sinister, right? Because they could have a badge number, which can then be used to hold them accountable if things go wrong or if there's a violation of the law that they have done. We need to be able to hold them accountable. And if you have a police department or a federal agency that's not cooperative and that is openly standing against the Constitution and individual rights and liberties, which we must always be suspicious of, because they're law enforcement, that's our job to be suspicious of them. Well, we need to have a way to hold them accountable. So a name tag, a badge number, and something that identifies what agency that they're working with. So again, this legislation was passed to enhance transparency and accountability, and ultimately public safety. Safety for the officials, safety for the officers, and safety for the public. So there have been some lawmakers and advocates that argue that these are necessary measures, right? It's necessary to prevent bad actors because there have been a number of instances now of people impersonating ICE, right? You get some Proud Boys. I don't know if Antifa is going to jump on that side of the argument, but you get some Proud Boys or some other individuals who take it upon themselves to enforce federal law when they have no authority to do so, and it's actually dangerous for them to do so. But they're doing these things and literally putting themselves and others in danger by impersonating law enforcement. Okay, that itself is unlawful. Another reason we need badges. We need We need to see their face. We need to be able to record them, and we need a badge number and a name to go with it, to go with the face. Now, there is a federal lawsuit. Like I said, this was filed by the Trump administration, and they're saying that these are anti-law enforcement or anti-immigration enforcement, anti-ICE laws, they say. Under normal circumstances, ICE is required already to wear name tags, badge numbers, things like that to identify who they are, so we don't start shooting at them. However, as we know with recent tactics and recent enforcement, they've set that to the side and instead are just tossing flashbangs and tear gas, shooting people with pepper balls when it's uncalled for, targeting members of the press, and that's why we need to hold them accountable. Normally, they would have badges. Under prior presidential administrations, they would. But now they've decided they don't want to because they don't want the accountability. Now, so we already shared the case number on that, so you have that information. Let's jump into the complaint itself, because this is one that's worth reviewing briefly. It's only a 16-page complaint. We're not going to read all of it, and we can skip the preliminary statements. I'll just give you a taste. Under President Trump's leadership and in response to the electoral mandate, the federal government blah, 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 blah. All right, so they're basically kissing President Trump's ass and praising him for his leadership and fighting. This is kind of ironic given the Epstein files. But he's saying the southern border was overrun by cartels, criminal gangs, known terrorists, human traffickers, smugglers, and unvetted military-age males, blah, blah, blah. Just complaining about the lax immigration enforcement at the border under previous administrations, which admittedly is a little more enforced now. So, again, a little ironic that someone embroiled in the Epstein controversy is being praised for his efforts against human trafficking. But let's skip that because none of that matters. The preliminary statement is really highly political. It reads like a campaign speech. It reads like something straight from the desk of the president talking about how great he is. And I think it's a little odd that we see that happening more and more recently. Whenever there's a cabinet meeting or a publicized event, you see people like Marco Rubio. Oh, thanks to President Trump and for his amazing leadership, or Pam Bondi or Christine Noem. Oh, I just want to thank the president. His leadership is so amazing and great and wonderful. The man's embroiled in controversy. All right. And my goodness, it's a bit over the top sometime. All right. So we're going to skip that. We know who the parties are. And then, the controlling law they cite as the Supremacy Clause. This is really the only part of federal law that this complaint hinges on, is a question of authority of the federal government based on the Supremacy Clause. And they do some abbreviating here. This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, ... Anything in the Constitution or laws of any state to the contrary notwithstanding. Okay, now that is one of the pillars of federalism. It's one of the pillars of the Constitution. And essentially what it says, and they don't cite it this way in the complaint, but what the Supremacy Clause means is, and this part's key, if there's an area of federal law that governs something, right? If the federal government has taken upon itself through authority granted to it via the Constitution, or so they've then passed a statute, or there's somewhere else in the Constitution that governs this. If there's something the federal government governs, then the states can essentially write whatever laws they want, but the federal law is supreme and will take precedence over it. Okay, so if there's a law that says let's say there's a state law that says there can be no blue gloves. You can't sell blue hand gloves because that's now a crime. Okay, and the federal government says you can't sell blue gloves, and you can't sell red gloves, and you can't sell yellow gloves because those are all now crimes. Okay, so the federal law is going to be supreme. So even though a state passed a law saying you can't have blue gloves, Actually, for the whole country, it'll be you can't have blue, red, or yellow because there's a federal statute about it, and that is the supreme law of the land. The federal statutes take precedence over state laws. Now, one thing you can do as a state is you can offer more protection under a law, but not less. So, for example, if in this example, the state says you can't sell gloves and you also can't sell shoes because now selling shoes is a crime. Okay, suppose that it's constitutional. Now, it's clearly not because it's a ridiculous example, but let's just say, for the sake of argument here, that a state can ban shoes if they want to, but there's no federal ban against it. Well then, in that state, you can't buy shoes. You could go to another state and buy shoes if you want, but you can't buy shoes in that state because they made a rule against it. And there's no federal statute that contradicts it. Okay, now we usually see something like this playing out in the realm of firearms, right? And firearms restrictions and firearms laws. So you can have states, right? You've got the Second Amendment that says the right to keep and bear arms shall not be infringed. Over the years, the Supreme Court has said, well, you can make certain restrictions if they're reasonable. Okay, so states like California had said, well, you can have it, but you got to go through this process first. Or you can own it, but you can't have more than a 10-round magazine, for example. You can't have these high-capacity magazines in California, right? That's the way the law used to be. I actually don't know what the current state of that is because I think it's changed over the years, but that's just an example, right? A state can allow more protection in the name of public safety, but it can't override a federal statute. That's the basics of the Federal Supremacy Clause. Okay, once you understand those two things, congratulations, you're going to pass that section on your bar exam. You're going to pass that part of your constitutional law class. That's the Supremacy Clause. Now, what Pam Bondi and, well, let's see, who's listed on here? We actually have Assistant Attorney General Brett Shumat, and this is all public information. We're not doxing anyone, right? Brett Shumat, the Assistant Attorney General, Civil Division. I see the Principal Deputy Assistant, Yaakov M. Roth, Eric Hamilton, Tiberius Davis, Sean Skidzilewski, Bilal. I say these are all assistant attorneys, U.S. attorneys from different divisions in the Central District of California whose names are on this. Okay, but it's being done by the U.S. The U.S. Department of Justice is suing the state of California. So it's the United States suing California for this. So ultimately that goes back to Pam Bondi. She's the head of the Department of Justice. Okay, so in here, let's see, we go back to the preliminary statement, go back to where we're party. Supremacy Clause, right? Talks about federal law enforcement, and they say, oh, it's the federal government's job to enforce the laws, and so we can do what we want because the federal government's supreme. That's a misstatement of the law, but essentially that's a summary of that section. They talk about some factual background, and now they mention the No Secret Police Act. And of course, their complaint, their beef is against the No Secret Police Act, and it bans certain law enforcement officers from wearing facial covering. Here's a quote right from the statute. Facial covering that conceals or obscures their facial identity in the performance of their duties. The No Secret Police Act requires law enforcement agencies operating in California to maintain and publicly post a written policy on the use of facial coverings. Now, that makes total sense. Let's think back just briefly now to what we're seeing in the lawsuits in Chicago, right? In the Chicago Headline Club v. the U.S., where there were these challenges to the way ICE was operating there. ICE, CBP, Bureau of Prisons is helping out there as well. That's BOP. And other federal DHS officers. And what the judge ruled is she granted a preliminary injunction saying, hey, you're here and you can enforce the law, but there's limits. You can't throw tear gas unless you warn people twice. You make sure they can hear the warning. They're doing something that's going to put your life in danger as an officer or whatever. And then you make sure they have a chance to move first, right? You can't do this. You have to wear a name tag and a badge number, right? So these are coming from a federal judge in the Northern District of Illinois who's already ruled on this in the form of a preliminary injunction in a lawsuit. because of the egregious violations of the First Amendment, of the Fourth Amendment, and unreasonable force that these law enforcement agencies are using against the citizens and residents of the Northern District of Illinois. Okay, so we're seeing these things play out in the form of court order and preliminary injunction there. What California decided to do is they said, you know what, we see this happening, and instead of all of our people having to go to court and get these same type of preliminary injunctions and then be challenged and yada, yada, we're going to make a state statute. Now, I think this is actually a pretty good strategy. Of course, now there's a lawsuit and they're going to have to respond to it, and there's a lot of good arguments in support of what California is doing here. Not only because it's forcing the federal government to follow the Constitution via a state statute, but as we're going to see here, there's really no federal supremacy that's going to preempt California from making or enforcing these laws. Okay. Now, the masks ban, as admitted here in the complaint, now remember this is written by the government, has narrowly tailored exemptions, including use for special weapons and tactics or SWAT teams. And it also talks about people doing undercover work, things like that. And willful and knowing violations are punishable as an infraction or a misdemeanor, right? So there is a manner of enforcing the law here, which is important. And they're not going to be able to assert immunity for tortious conduct. Now, this is important. There are already Supreme Court decisions stating that a federal officer who's operating in a state typically are going to be immune from prosecution when they're doing their duty. And they're doing their duty correctly and constitutionally and in conformity with state and federal statutes. However, they do not get civil protection, civil immunity from a tort. So if you have a federal officer who unprovokedly tackles a protester, right, without reasonable cause, right? They're just out there and they're like, you know what? We're law enforcement. We have immunity. Tackle. And they tackle a guy to the ground and he suffers injury and he files a federal lawsuit. That officer is not immune from a tort. Okay. It doesn't exist. Like I said, we'll go over some of the Supreme Court decisions on that. And this statute is really just reinforcing that, saying you're not exempt from tortious civil liability, statutory damages, civil damages, etc. So that's the No Secret Police Act, essentially saying you can't have facial coverings that obscure your identity. The law enforcement agencies operating in our state have to post a policy about the use of facial coverings. And let's see, I want to see if there's one more thing I wanted to talk about in there. No, because this is all about facial coverings, masks, things like that. Okay. Now, under the No Vigilantes Act, it's a little bit different. There's a couple separate things. And again, the No Vigilantes Act was passed because what they were seeing is vigilantes, right? Dressing up. And it's not hard to look like ICE. Literally, I bought an ICE hat and I bought a CBP baseball cap on Amazon, and it wasn't expensive. So you can find those there. So you can get yourself some ICE apparel. You can get yourself a bulletproof vest or some tactical gear. All you got to do is go to the military surplus store or, again, hit it up on Amazon. You can get a pair of blue jeans and some ugly, nasty, smelly t-shirt, right? And then you have your ICE or CBP outfit that they're wearing, these plainclothes officers who are out there without badges on. And you don't even need to worry about a badge because ICE isn't even using them, right? So you don't have to worry about that. So the No Vigilantes Act, I'm just going to read some of this from the complaint, was also signed into law September 20th this year, and in relevant part takes effect January 1st, 2026, so coming up. It requires non-uniformed law enforcement officers operating in California to visibly display identification, which must include their agency, and either a name or badge number, or both a name and badge number, when performing enforcement duties. So they cite to the No Vigilantes Act, Section 10. Okay? Doesn't sound very controversial because this is what the police usually do. This is what any law enforcement agency usually does. Okay? It requires law enforcement agencies operating in the state to maintain and publicly post a written policy on the visible identification of sworn personnel. So again, you have a requirement to publish your policy on when we got to use identification, when we got to have our badge numbers and names displayed, and when not. And let's even point out right now, in the very next paragraph, so this is actually paragraph 45 of the complaint. This is the government admitting, right? They're admitting that it's not discrimination because they say the policy, this paragraph 45, the policy requirement applies to any law enforcement agency operating in the state. Oh, sorry, I misread. The policy requirement applies to any law enforcement agency, department, or other entity of the state or any political subdivision thereof that employs a peace officer, any law enforcement agency of another state, and any federal law enforcement agency. And they cite to the statute there too. That's in section 2C2. So what do we have here? The policy applies to everyone. It applies to all law enforcement. It's not a policy that applies only to ICE or only to CBP or only to federal law enforcement. It applies to everyone. That means it's generally applicable, which means it's not discrimination. Okay? They're not discriminating. They're not saying, no, it applies to you, but not to you. It applies to the federal government, but not to the state. No, they're not saying that at all. It applies to everyone. And there's really good public policy behind this. All right. They include the requirements of what the policy statement needs to include, things like that. Okay, so that's their beef with it. Now, the next section is simply titled, "The United States will not comply with either law." This is not a section you include in a complaint in federal court. You don't just come out and say, we're not going to comply with it. This is poor drafting. Okay, but again, what we've seen under the Trump administration in a lot of these politically charged complaints is high praise for the president and a bit of sassiness. These are getting pretty sassy and they're disrespectful to the court and to the opposing party. We got to remember we're not enemies with these people. They are on the other side of a policy decision and of government operations, but we should not be enemies. Okay. That is like rule number one of drafting legal documents. You don't want to insult your audience. You don't want to insult the court's intelligence by making these, the United States will not comply with either law. Federal agencies cannot and will not comply with the challenged acts, which are unconstitutional and recklessly disregard officers' safety and federal operational needs. Extraordinarily dangerous, blah, 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 blah. Okay, so they go on to cite increase. I don't know how this is, 1,000% increase in assaults against them, 8,000% increase in death threats against them. These come from rioters, illegal aliens, highly sophisticated gangs trained in Nicaragua, which somehow is the gang du jour, right? They get blamed for everything, right? All right, so they go on and make their complaints in that section about all the reasons it's so dangerous to operate. And finally, we get to the claims for relief, right? And count one, violation of the Supremacy Clause, unlawful regulation of the federal government. Okay, the Supremacy Clause doesn't say that. Like we covered earlier, the Supremacy Clause says federal law is supreme. So if there is something the federal government passes, a law or a statute, then that rule is supreme. So if the federal government has their own No Vigilantes Act or their own No Secret Police Act, then yeah, California's can offer more protection to the people, but it can't offer less. Okay, so even if the federal government had those acts, it's not like California can't do anything additional to give more protection to the citizens of the United States in California. So again, that's their count one, and it lies solely on the Supremacy Clause. Count two, again, violation of the Supremacy Clause. They say it's unlawful discrimination against the federal government, even though in what we just read in their complaint, they admit that these statutes apply to federal and state agencies, this state, so California, or other states, or any other law enforcement agency, federal or whatever. Okay, so it's broadly applicable. It is not something that's targeted at the federal government. One of the purposes is because the federal government is abusing the rights of American citizens living in California, but it's not discriminating against them. It's not based on the government's viewpoint. It in nowhere prevents the government from doing their job. It doesn't say you can't arrest immigrants in California. It doesn't say you can't stop and question people in California. It doesn't say you can't do your job that's lawfully appointed to you under the statutes and the Constitution of the United States. It just says when you do it, you can't wear masks and walk around without any ID, without any badge number or name tag. So the real question, so then there's the prayer for relief, which what are they asking here specifically? They want a court judgment declaring the provisions of those acts that they violate the Supremacy Clause and are invalid. They want a preliminary and permanent injunction that prohibit the defendants from enforcing those provisions, and that this court award the United States its costs and fees in this action. And that this court award any other relief it deems just and proper. So that's rich. The United States government asking for costs and fees from a state. The federal government prints money. They literally can print money. They can loan it out. They can borrow money by loaning it out. They can raise money that way. They don't need an order against California for costs and fees in an action like this. That's laughable. All right, so that's the complaint. Now, what are the arguments, right? We've gone over the complaint. We've gone over the arguments. So what are the arguments against what the government's saying here? Okay. Let's look at North Dakota versus the United States. Now, this is a Supreme Court decision from 1990. Okay, now what happened in this case is you had the federal government passed a law governing how the federal government purchases alcohol to sell on base, right, on a military base in North Dakota. And North Dakota had their own system of laws for the sale and importation of alcohol. Now, the federal government was not following that law, so North Dakota sued. And let's open up the decision here. And essentially the argument was, well, the federal government already made a rule about how the federal government should buy alcohol. So therefore, because of federal supremacy, the federal government shouldn't have to follow the state rule. And let's read what the federal government, or what the Supreme Court ruled in that case here. Okay. Here's from the decision. That is not to say, of course, that the state may enact regulations that discriminate against the federal government, but for reasons already adverted to, the North Dakota regulations do not do so. Okay, and earlier in the decision, they talk about how these regulations apply to anyone importing, buying, or selling alcohol in the state. In giving the federal government a choice between purchasing label-free bottles from in-state wholesalers or purchasing labeled bottles from out-of-state distillers, North Dakota provides an option that no other retailer in the state enjoys. That being so it gives more options to the federal government, right? That being so, the labeling requirement for liquor destined for sale or use on non-exclusive federal enclaves does not violate any federal immunity. So this is like this No Masks or No Vigilantes, or No Secret Police and No Vigilantes Act. It doesn't violate immunity. It's providing more protection for people in the state, and there's systems of laws and rules and regulations that states can enact as long as it doesn't conflict with a federal statute. Now, in the federal complaint, in no place does Pam Bondi or those who drafted this piece of garbage, nowhere do they state a federal statute that already governs the actions being taken. To invoke federal supremacy, you need that. You can't invoke the federal supremacy. And this is so funny because, I mean, after just reading this, I can remember this from law school, right? Law school was almost 20 years ago, but this is like the real basics of the Federal Supremacy Clause. If you're going to say the federal government is supreme and doesn't have to follow this rule, you got to tell me the federal statute that's already governing these actions. And they don't do it anywhere because apparently there isn't one. So North Dakota v. United States provides one authority from the Supreme Court. It's recent. It's 1990. It's relevant. Okay. We have another one. I don't know if I highlighted anything from here specifically. Let's pull this up. Here we go. There was a bedrock case on the federal Supremacy Clause immunity that comes from a case from 1890. Okay? And when we want to invoke the Supremacy Clause, this is one of the cases that we need to look at. It involved a U.S. Marshal named Neagle, right? Spelled like beagle, but with an N, who shot and killed a man to protect Supreme Court Justice Stephen Field. California charged Neagle with murder. So that was the U.S. Marshal, a federal officer doing his job, who killed someone protecting a Supreme Court justice. So he was doing his job. The Supreme Court ruled that Neagle was immune from state prosecution because he was acting under authority of U.S. law. His actions were necessary and proper to discharge his duty. So from that case in 1890, we get a test to claim immunity from state law. So if we're saying we're immune from it, which isn't really an argument under the Supremacy Clause, although it's adjacent to it, but it wasn't listed in the complaint. So it wasn't raised in the complaint. But so the question, are you acting under the authority of U.S. law? Okay, so when ICE is snatching people up while not wearing badge numbers or identifying information and while wearing a mask, are they doing those things under federal law? And you can say, well, when they're snatching people up who are undocumented, they're doing their immigration enforcement responsibilities, which is part of their job under U.S. law. But then the question is, are the actions or the way that they're doing it, is it necessary and proper to discharge their duty? So is it necessary and proper for them to wear a mask? Is it necessary and proper for them to not wear a badge number or a name tag when they're doing that? So that's called, that goes to the Neagle test. And to claim immunity from state law, the federal agent has to show that they were performing the act authorized by federal law. It doesn't have to be explicitly mentioned in the statute, but they do have to be able to claim that this act they're doing is helping them fulfill their duty and that it's reasonable, right? That what they're doing is necessary and proper. They did no more than what was necessary and proper for them to do it. And the officer needs an objectively reasonable belief that the actions were necessary. Now, that's something that fails when we look at what ICE is doing. Do you have to wear a mask in order to arrest immigrants? No. Happens all the time. People unmasked arrest immigrants. Do you need to not wear a badge number or identify your law enforcement outfit when you're out walking around looking for people to arrest? No. Now, there's an argument that if you're doing an undercover duty, yeah, you can't be wearing all this identifying information. Okay, but you should be showing a badge when you do arrest someone. And a lot of the actions that ICE is taking, and when I say ICE, I mean ICE, CBP, they're bringing in the Bureau of Prisons personnel and other DHS officers. They're bringing them in, and many times it's not undercover. They're not doing like undercover work where they have to be undercover in order to do the job, right? They're not infiltrating Tren de Aragua, right? You're not going to infiltrate a gang and go undercover while wearing a badge. They're going to know you're a cop. So there's this two-part test. And this doesn't get mentioned at all in the complaint. So in a complaint, when you're drafting a federal complaint, the best practice is to give as much detail as you can. And you want to anticipate the defenses that the other side is going to raise. Because if you can do that, you can ask for things like a preliminary injunction. If you do that, you can ask for things like summary disposition. Now, statutorily and under the court rules, federal practice is notice, right? You got to give notice to the other person what you're suing them for. This I would classify as sort of a bare bones complaint, full of puffery, full of praise and butt kissing to the President of the United States, praise for him and his glorious actions and his leadership, quote, I'll put that in quotes, his leadership. But it's very thin on the law. All they're listing here is the Supremacy Clause of the Constitution. They don't mention any other statute that gives them authority. They don't mention the Neagle test. They don't mention any of the other core Supreme Court decisions and why it's clearly in the government's favor, because it's not. And I think we're going to see a really nice response to this. Some other cases we took a look at here. If we look at McCulloch versus Maryland, this is another one, 1819. This is a famous Supreme Court case that basically states that states cannot generally impose licensing requirements or direct regulations that control federal agents. However, federal agents are generally expected to obey neutral state safety laws, and these statutes in their text are to provide safety for the citizens of the United States living in California. So if we frame these as safety statutes, it's a state safety statute. It's clearly within the bounds of McCulloch versus Maryland. If we look at, let's see, there were a couple other precedents I wanted to look at. We talked about North Dakota. That one really doesn't matter. There was this one. You know what? Here's a question. If you find yourself on arguing a case and you're looking up cases that are going to potentially support your side, and you find something like this case here. This is the Church of the American Knights of Ku Klux Klan versus Carrick. Okay? If you find yourself looking at a case where the Ku Klux Klan is a party, it might be a good time to stop and reflect on what your arguments are, what you might ultimately be arguing for or against, and how in the heck did I end up arguing something on the same side as the Ku Klux Klan? In that decision, essentially what happened is this. You have the Church of the Ku Klux Klan who said, we want to wear our outfits at public gatherings and at, town council meetings and city meetings and things like that. Well, that wasn't very popular, so the state passed a statute against it, saying essentially, you can't wear your Ku Klux Klan hood at a public gathering, and you can't wear a lot of these things in public. Now, there's exceptions, though, for a masquerade or a party or things like that, right? So they tried to craft some exceptions in there. But ultimately, the Supreme Court decided, no, this is a free speech issue. And because it's a free speech issue, if you're going to let some people wear a mask, everybody gets to wear a mask, right? You can't discriminate because they're the KKK and because they're awful, horrible racists. And in some ways, we need groups like the KKK to try and push the envelope and for people to overreact to so that we can go to court and we can really define what the rights are, what the freedom of speech protects. Because if you're not going to protect the freedom of speech of one group, well, then it's pretty much everyone's freedom of speech is going to be gone in due course, because at some point, your opinion might not be popular anymore. Hopefully it's not as racist as the KKK's, but your opinion might not be politically popular anymore, and then your speech could be banned as well. So in this other case I found, I've got one more, Jacobson versus Massachusetts. It's in 197 U.S. 11. It's from 1905 on the very popular topic of vaccinations and whether a state can obligate its citizens to get vaccinated. Kind of relevant given the whole COVID vaccination stuff recently. But we're not going to talk about vaccines itself because that is just, oh my goodness, there's so much to go on there. But here's one of the lessons from that Supreme Court decision. The police power of a state, right? And that's the police. The police power is what the state of California relies on when they pass a rule governing how the police need to act in their state. It's literally enforcing their police power. The police power of a state embraces such reasonable regulations relating to matters completely within its territory and not affecting the people of other states, established directly by legislative enactment, as well as protect the public health and safety. While a local regulation, even if based on the acknowledged police power of a state, must always yield in case of conflict with the exercise by the general government of any power it possesses under the Constitution, the mode or manner of exercising its police power is wholly within the discretion of the state, so long as the Constitution of the United States is not contravened, or any right granted or secured thereby is not infringed, or not exercised in such an arbitrary and oppressive manner as to justify the interference of the courts to prevent wrong and oppression. Okay? So what is that telling us? Yeah, if there's nothing the federal government has in the Constitution or in a statute that contravenes it, yeah, the state can use its police power to pass these laws. Now that was talking about vaccination. Here, of course, we're talking about whether law enforcement can walk around without badge numbers, name tags, or while they're wearing masks and anonymously grabbing people off the street. So I think the government has a very high burden here. What they would need to show in order to win this case is they need to show that it's impossible for them to do their job without a mask. That it's impossible for them to do their job if they're wearing a name tag or a badge number. And we know it's possible. We know how the Northern District of Illinois feels about that, because in their preliminary injunction, dealing with the chaos that ICE, CBP, BOP, DHS, and other federal law enforcement agencies have caused, they included it in their preliminary injunction against them. They included it in the order that says, hey, you can do your job, but you got to wear a name tag. You can do your job, but you got to identify yourself. You can do your job. I don't remember the rules on mask for that one. I don't know if they touched the topic of mask, but they have to at least be identifiable by badge number or name. Okay, so that's one of the recent cases that's hit the news this week. There's no response filed yet. When it does come out, we'll take a look at it. Maybe it's something we'll do an episode on as well. But I want to thank you for joining us today. Please, if you enjoyed this, if this is a good use of your time, like and subscribe. Find us anywhere you find your podcast. That could be on YouTube. That could be on Spotify. It could be on Apple. Actually, I know a lot of people are protesting Spotify right now because they are running ads for ICE and DHS and CBP. So find us on YouTube. That's generally there. It's generally available anywhere else you find your podcast. And again, we're brought to you by Prima.Law, which is professional immigration case management. We are legal case management. So even if you're not specifically an immigration attorney, you can use Prima.Law to manage your legal practice with a full set of tools, including tasks, note-taking, contact management, case management, billing. We do have immigration forms. We do have some other federal forms as well. We do have some state forms for California and for the state of Michigan as well. You can find all these features, including trust accounting, billing, so you can invoice your client. You can have a client portal. You can share checklists with your client. You can do all these great features for a very low price. You can find us at www.Prima.Law. Find a free 15-day trial. And thank you for joining us.